Welcome to this free immigration help channel. Today is March 4th, 2023, and we are getting into volume 24 of me answering your immigration related questions. Now, before I start, I'm gonna mention, as I always mention in every video, this is not a legal advice. I'm not an immigration attorney. All the information that I provide in on this channel, in my videos, is directly from official sources like USCIS.gov and state.gov, which you're probably gonna use in this video. So without further ado, let's start with the first comment from Gebrewet Essayas, and I'm sorry if I mispronounce your name. Hi, I have my wife case take long to schedule for visa interview. I got approved August 24, 2021, and I paid all the fees, all the documents, but till now they didn't schedule for visa interview. How's it gonna take to get scheduled interview? Please, thanks in advance. Okay, so whenever it comes to, so I'm assuming you're, either U.S. citizen or legal permanent resident, obviously, if you filed for your wife, a petition I-130. So if your case has been approved by USCIS, it was transferred to the NVC. You say that you paid all the fees, you submitted all the documents. Now, my follow-up question is, has the case been approved by the NVC side? Has you received a response from NVC saying that that's it? You're basically documentarily qualified. All of the documents they received, they accepted. The sponsorship information, they have accepted. And they are basically in the process of transferring your case further, still within the Department of State, but now to the actual US Embassy where the interview is going to be taking place. The reason why I'm asking it is because whenever it comes to spouses, whether permanent resident or US citizen, there is no visa cap. So there is really no waiting that you need to do. Maybe just a couple of months until the case is transferred between the departments, between the whoever. But there is really no wait time per se. Just the wait time for the transfers of the case. So in your situation, if it has been already approved by the NVC, if they said that they received all the documents, since August 2021 to transfer and to schedule the interview, this is taking too long. And even if they have not reviewed it yet, if you submitted everything and you have not heard back from them just yet, what is it, a year and a half, 2 years? Well, not 2 years, a year and a half. It's taking a little bit too long regardless, whether they reviewed it or not. So I would recommend, if you Google Department of State Public Inquiry Form, you will have, it's an official government, you will see it ends with state.gov, just a online public form, fill it out with your case number, with everything, and submit it and see what it says. But also I wanted to ask you, what does it say actually when you log into your NVC portal? What does it say? Does it say still in review or has it been already approved? So if you can follow up with the answer, I would really appreciate it. I'm gonna post this so you're aware that I responded. Now this video will be posted a little bit later today at 6 p.m. It's gonna go live. But let's move on for now to the next question from Musa Han Ahmadzai. I have lost my EAD card and meanwhile it is going to be expired. So in the form, which one should I select? Replacement of lost, stolen, second renewal of my permission to accept employment, or both of them, since I have my physical EAD card to attach with. Yeah, okay, so very, very good question. Now, I'm pretty sure whenever you're filling out I-765, whenever you have that selection, whether you're replacing or renewing, you can only select one. I want to double check. I'll use this as an opportunity to show you some navigation in USCIS website, which is the official website for US Citizenship and Immigration Services. Make sure it's .gov at the end. That's really what the government websites. Nobody can fake that. So we're gonna go to forms, and then we're gonna click on all forms, and then we will just type in 765 here, so that we don't have to scroll through all the forms. There we go. So this form is available to file online, which I recommend doing, but to check, I'm gonna click on this. So this is the part 1 right here. Initial permission to accept employment. Yeah, so you can only select one. So in your case, I would definitely put the replacement of lost, stolen, or damaged employment authorization document. Why? Because if you do select the renewal, in that case, you will have to attach a copy of your previous employment authorization document, which you don't have. So definitely this one for you. All right, so I'm gonna get out of here. We're gonna go back to the homepage, and I'm gonna let you know that I have answered your question, and we're gonna move on to the next one from Amar Han. I'm in US resident with green card. How much it takes time to bring my husband with me, please guide. Is my husband can come to USA on my behalf? Okay, so I'll start with the last question. Yes, if you are a permanent resident, yes, you can invite your spouse and your children. If you're a US citizen, you can invite your, not invite, you can petition for them to immigrate to the United States, for your spouse, children, your parents, your siblings. Okay, so to answer your first question now, there's a couple of processes involved whenever bringing in your alien relative. The first stage is through USCIS, and you have, let's see, okay, so you commented on this video, the interview questions. So you still have time before the interview. You actually need to check out the video that I've done. It's I-130 step-by-step filling out the application, because that is the first step, filing it with USCIS. So to answer your question in a little bit better detail, I'm going to show you the processing times for USCIS. And again, it's a good opportunity for me to demonstrate the navigation. If you can follow, I'm sorry if I'm doing this fast, but I actually done separate videos on this, so I'm not going to. So I-130, petition for alien relative. Now you said that you are permanent resident, filing for a spouse. So this is going to be the number one. And depending which service center your application goes to, depending on where you live, usually they're very, very similar in processing times, not by much. So about 2 years in California. Let's check Potomac, just to kind of give you about a little bit more in Potomac. So what is it? 2 years and, my math is horrible, and 5 months. 2 years and 5 months in Potomac. So about 2 years for USCIS processing, right? Once USCIS processes your case, they send it to the NVC for further processing once USCIS approves it. And then the NVC does the further processing, and whenever it comes to the NVC, usually for spouses, for children, they process stuff a little bit faster, because there is no cap, like I've mentioned in the first question that I was answering. There is no cap for those visas, which means they are unlimited availability. But you still have to give it about 6 months. So I would say total about 3 years. That should be kind of an estimate for you. Again, it might take faster, it might take slower. A lot of the stuff depends on you yourself, because once you get your USCIS side approved, you have to do a lot of work of your own. I mean, USCIS, you're doing it all yourself too. You're filling out the application and stuff. But the NVC, that is a whole next level, where you have to pay the fees, where you have to fill out a few other applications, where you have to submit a bunch of documents. So you have to stay on top of things. So it's good that you're finding out information beforehand, but I highly recommend checking out that I-130 step-by-step, where I explain how to file the initial application, and I recommend starting it as soon as possible, because as you can see, this process does take some time. Okay, let's move on to the next question from Mizanur Rahman. And again, if I'm mispronouncing your names, I'm sorry. I am applied from California in 2019. How long it takes time for my visa interview? F4 visa petition. Okay, so the F4 is a priority category. I do have the visa bulletin here. This is for March 2023. If you haven't seen the video that I've made specifically on how to understand the visa bulletin, check it out. This is it. This is the video right here. It's called Understanding Visa Bulletin. Why is there an immigrant visa backlog? And there I talk about this different graphs that are available, different categories, different chargeability areas, and so forth. So check it out. If this, what I'm saying right now, is a little bit confusing, check it out. It will clear things up a little bit. But F4 visa petition, so that's the fourth priority category. That's brothers and sisters of adult US citizens. So if a US citizen files a petition I-130 for their brother or their sister, they will be in this fourth priority category. And if you look at these two different graphs, they don't have much difference between them, but they are different by a few months to a year. Basically, the first one is when everything was already documentarily qualified, and the second one is when the initial application I-130 was accepted by USCIS. That's the date on the initial receipt notice. So in your situation, Mizanur, let's see, you filed in 2019, so you just applied. So you just applied in 2019, so the receipt date is from 2019. So we're gonna look at the second graph, and F4 currently they are processing. I mean, it depends on, again, from which country you are petitioning for your sister or your brother, or if it's for you. I mean, I don't know if you're the petitioner or if you're the, I'm assuming that you're a petitioner because you say you applied. So I'm assuming you're petitioning for your brother or your sister. But regardless, it's the date the priority date for the F4 is from December 2007, which means right now, as of March 2023, they are issuing the visas to people who had the filed and the USCIS case was received back in December 2007, and you filed in 2019. So right now, as of right now, from 2023 to 2007, there is let's see, again, my mathematics skill, 16 years delay. 16 years delay. Now you filed in 2019 plus 16, that's 2035. So with a very, very rough estimate, is 2035 is when your visa is going to be available. So around that time, there's going to be the interview once you're documentarily qualified with the NVC. After that, obviously. The reason why it's a very rough estimate is because these dates, they do change. Every month, Department of State, they release a new visa bulletin, and I will actually make each month, once the new one comes out, I will make a separate video to kind of go over the dates and give these estimates. But sometimes they slow down, sometimes they speed up. So very, very rough estimate, but around 16 years wait time from 2019, that's 2035. Unfortunately, it's very long, I know, and I can personally relate because I have someone who is in F4 category who I petitioned for, and they still have about 15 years to wait, which is crazy, I think, but this whole other conversation. Let's move on to the next question for now from Hypnosis. In the employment history part, do we need to put the local address of employer on my hometown or the address of employer on the W-2 form? Hussein. Okay, Hussein, thank you for your question. Yes, definitely put the local address of the employer, especially, you know, with the big corporate or whatever chain stores, you know how it is. They have a corporate address, the main address for everybody, and then there's the local, whether it's restaurants or whatever chain, right? So definitely put the local address where you actually were working, unless you were working in the corporate where they send the W-2 form. Okay, let's move on to the next one from Miyamalang Kadri. My entry was to USA on April 10th, 2022, and I will be eligible to apply till 9th April 2023 if I apply and post and sign my document, and on 8th April 2023, only one day before expiring my 1 year here in USA. Is it work or how? Okay, so that was an application for asylum. Okay, Miyamalang, this is really bad plan. Really bad plan. I don't recommend doing that at all. First of all, I think you misunderstood the whole asylum and the purpose. Within the year, it's not when you are eligible to file, okay? You can file for the asylum anytime you want. You can file for asylum 3 years after entering the country. It's just within 1 year is what they expect for really common sense reasons, because if you are running away from a country where you're persecuted, right, you want to reassure your safety as soon as possible. So your priority will be number one, to file the asylum application, right? So you came into the United States of America, You're here for a day, you're here for a week. Your first priority is to make sure that you're staying here and not going back to where you came from, because it's dangerous for you out there, all right? If you're filing a real asylum application. Within a year, that's the reasonable expectation. You can file past the year, but during the interview, you will have some serious questions. Like, why weren't you concerned with your safety, basically? You're applying for asylum, but here you are filing it a year after being here in the United States, right? So whoever is applying for asylum, I wouldn't recommend waiting any time at all. You do it as soon as possible. I'm not sure why you have this plan to drag it out for a whole year, but honestly, I would definitely recommend you going through the asylum itself, understanding it a little bit better, because to me, from reading your comment, it just doesn't seem like it is an option for you. Okay, because if that was the only option for you, you wouldn't be asking that comment, if it makes sense. I'm not trying to kind of discourage you from anything, but asylum is a serious process, and if you don't meet those eligibility requirements, I wouldn't even recommend going there and starting it, because it's really complicated. A lot of times it is lengthy. A lot of times you have to provide a lot of information, and if you does go to court, a lot of times you have to go and hire an immigration attorney, which ends up costing quite a lot of money, especially with the asylum cases. So yes, okay, with that being said, let's move on to the next comment from Chris Gilda Garcia. Very sorry if I mispronounce your name. If petitioner an active US Marine, can you expedite, please? That's on understanding visa bulletin. All right, thank you for the question. Actually, really good question. So I'll probably make a separate video on expediting the process. Yes, there is a way to expedite, not expedite, I'm sorry. There is a way to request an expedited processing from USCIS, and also request an expedited processing from the NVC, from the Department of State. Unfortunately, there is nothing specific for military, so there isn't really anything specific in your case, Chris Gilda. Sorry if I'm mispronouncing the name, but there is a way to actually request that expedited processing. There is a few kind of things that the USCIS and the Department of State look at. First of all, if there is like a hardship, if the petitioner is very ill, right, and maybe it's some kind of terminal illness. Basically, there is a limited time frame, right, for the petitioner. Or for example, if the beneficiary, there is a threat to their life. So I will make a separate video on that. However, still I would say take it with a really big grain of salt, unfortunately, because whenever it comes to requests for expedited processing, 99.9% of these requests, they're denied. No matter how appealing they seem, no matter how good they seem to whoever is submitting this request, most of the times USCIS or Department of State, they deny them. It's not good for USCIS or the Department of State. Another reason why you should take it with a grain of salt is because your visa has, your immigrant visa for the beneficiary has to have already, it has to be available for the NVC side to actually expedite your case. Not only that, on the NVC side, you also have to be documentarily qualified, which means that beforehand you cannot request the expediting. So once you get documentarily qualified, once your visa is available, only then you can submit that request to expedite the case, which is kind of pointless, because once it is documentarily qualified and once your visa is available, it's just a matter of a few months max. All right, so requesting that expedited processing is pointless. Unfortunately, I wish I could give you something a little bit better, but that's just the way it is at the very moment. But regardless, there is a way to expedite it. I mean, even if you just Google it yourself, you can put in expedite processing NVC, and it will come up. You will have the email. I think it's NVC expedite at state.gov, something like that. But again, I will make a separate video on it if you still want to do that. Okay, let's move on to the next one, and I'll try to answer questions up down to here so that this video is not too long, and then I will address the rest in the next video in my volume 25. Okay, so the question from Abdul Rahman. I have already paid for the N400 and my biometrics is already scheduled. Can I still submit the waiver and get it waived? So that was a question on, so that was on I-912, the fee waiver from USCIS. Okay, Abdul Rahman, unfortunately, on the application that has already been submitted, you cannot file a fee waiver, especially on the application that you have already paid for. Unfortunately, when you're filing the I-912, you actually have to file it together with the application. It's very important. So yes, unfortunately, no. I know it would be nice, and I know I've been there. I've been there where I paid the application fee and then I realized, and it was really hard during those times too, because when you're starting as an immigrant, I mean, at N400 naturalization, you're already, doing a little bit better, but, paying for employment authorization documents, paying for the green card, quite a lot of money total. And back then I did not know that there is an actual fee waiver. So yeah, see, it's important to do your own research. You know it. You realize it a little bit too late as well, but at least you can recommend it to your friends, your relatives. Okay, let's move on to the next one from Ace. Okay. My case F1 Philippines priority date April 9, 2012, documentarily qualified. February 2021. Okay, so priority date is April 2012 and documentarily qualified February 2021. So I have been waiting for almost 11 years. Still no interview date given. Anyway, still happy spending my time here in the US as a tourist. Yeah, so here's one thing. Thank you for Ace. I'm gonna call you Ace. Thank you for posting this comment, for posting this update. Because after posting this video, Understanding Visa Bulletin, I got a few comments from people that clearly do not understand the process and do not realize how backed up these immigrant visas are. And F1 category is children. It's unmarried sons and daughters of US citizens who are over 21. But still, these are sons and daughters of US citizens. That's the first priority category. That's number one. You would think it would be processed really quick. Nope, unfortunately it's not the case. And there you go, you have a person who's been waiting for almost 11 years. And they will be waiting for some more because priority date is from 2012. Okay? That's for Philippines. And you will see Philippines, they have their own separate chargeability area. It's a separate chargeability area because immigration numbers from Philippines are heavier than, well, pretty much the rest of the world, because you have China, separate chargeability area, you have India, you have Mexico, you have Philippines, and then everybody else is in all chargeability areas. But yeah, this is the real problem, and people are still waiting, and unfortunately, Ace will be waiting quite some more time for the visa to be available. And it's ridiculous because his parent is a US citizen. Why is he waiting? At least he has a chance to come here on a tourist visa and visit the parents. But still, what's the purpose of this waiting? It makes no sense, unfortunately. So thank you, Ace, for posting this and for showing people that this is not a joke. All right, let's move on to the next one from KST USA. Hey bro, I need to bring my wife in United States. How can do that? And then there is an answer from Phone Lionel. Phone Lionel, by the way, thank you for answering. Please, you can just fill in the I-130, from which will give you the opportunity for your wife to immigrate to the US. It's possible either you're a permanent resident or a US citizen. Yes, phone. No, thank you for answering this question. It is correct. KST USA channel. If you are a permanent resident. Sorry, been talking for too long. If you are a permanent resident, or if you are a U.S. citizen, you can petition for your wife to immigrate to the United States of America. And you do that by filling out the form I-130. Now, this video is about the interview. So this is a final stage of the process. You need to find the video on this channel that I've made. It's called I-130 petition for alien relative, step by step, how to fill out the application. And basically it describes the process from the very beginning, from where you need to file the application with USCIS first. Once it is approved on USCIS side, it is transferred to NVC, to the Department of State, for further processing, and that's a whole other area. But for now, you need to start with the actual application. All right, so we have a little bit more time. I'm gonna move on to the next question. It's not a question, Danielle Safat, you're awesome. Doubt it, but thank you very much. I appreciate it. I appreciate your kind comments, always your support. That really means a lot. All right, let's move on to the next one from Rosaline Earls. I filed for my 3 children since 2015. Till now, we have not heard anything from Nigeria. Rosalind, I'm very sorry you're experiencing this. Unfortunately, so if you're filing for 3 children and it's been since 2015, I'm assuming that you're a U.S. citizen and that your children are unmarried children over 21 years old, and that's why you're waiting so. Because that's the only explanation that I can find for waiting so long. So if you have filed back in 2015, again, we're going to look at our F1, first priority category, and since you are from Nigeria, then you are in all chargeability area, and I'm going to assume that your case was actually received by USCIS in 2015, so the priority date would be the date of filing, and F1 category is August 2016, and you filed back in 2015, so it should have been already processed. I'm thinking you might already be more than that, so I would say you're like right there. You're right there. You waited long enough, and the visa should be available like within no time at all. Hopefully. I'm really hoping that it's not going to take any longer for you, because you've been waiting quite a long time for your children. But I do want to ask you if you can follow up with where in which process your application is in. Has it been already documentarily qualified by the NVC? If it has, let me know. That would be great, because I would be able, if I knew that, I would be able to provide a little bit more information, possibly a little bit more estimates and predictions. Okay, looks like we have a little bit more time. Let's try to answer another question here from Simone Williams. My priority date is 2017 June. Can you tell how long will I be waiting? Okay, so priority date is 2017. I don't know your category. I don't know your which country, your chargeability area. But if it's 2017, I'm gonna take a guess and see. There's January 2017 here for F2B, and F2B is unmarried sons and daughters 21 years of age or older of permanent resident. So January 2017. So 2023 right now is 6 years. We have a delay of 6 years for F2B, and again, it's my assumption because you said it's 2017 your priority date, so I'm assuming January, there's the only one 2017 on both of these graphs, so I'm assuming that's F2B you're asking. But regardless, even if it's not F2B, the way I do this calculation, you will be able to do it yourself on your category, right? So let's say you're F2B in 2017, like you said. Right now it's 2023, so as of right now, March 2023, there is 6 years delay. There's a 6 years backlog on these immigrant visas that the Department of State is issuing. All right, so 6 years, let's say as from now, right? When did you file? Okay, so I don't know when you filed it, but let's say if you filed it back in 2020 and 3 years already passed, so you have 3 more years because its total backlog is 6 years. So in 2026, you should be, moving along, your visa should be, available. Again, it's very rough estimation. Why? Because these dates, they change. Sometimes they speed up, sometimes they slow down. And why it depends. And for example, let's say in what is it, 2023 right now, right? Let's say in 2023 there will be more people applying in F1 category more than there are available visas available. I'm sorry, I've been talking for a whole 30 minutes, but there's, let's say in 2023 there's more people applying for F1 category, petitioning for their unmarried sons or daughters, their US citizens petitioning for this, more than there are visas, immigrant visas provided for the 2023, because there is a cap on that category, and you will find the cap information for each category here written on the visa bulletin. That's why it's helpful. That's why it helps to understand it. Again, if you haven't seen this video, Understanding Visa Bulletin, check it out. There I explain all of these details. But if the cap is passed, right, if there's more petitions than there's available visas, this backlog is transferred to the next year. And if the same thing happens with the next year, this backlog will transfer to the next year. And with that being said, it means that it's growing, it's getting worse, it's getting slower. Now, if there was less petitions than available visas, now we're getting the speed up, right? So very, very rough estimate. It can speed up, it can slow down. But with that, I'm gonna put this and I'm gonna say that it was answered, so that you're aware. And you know what, maybe we'll get to this one as well. From Mahriban Babaeva, we're gonna answer that as well. Thank you. Tell if one of the spouses is not Ukrainian. How can I show that? Where I can attach marriage certificate? All right, Mahriban, great question. So luckily USCIS, they actually they changed. It's no longer the I-134 that you have to file in the paper application. It's now a separate I-134A that you're filing online. So whenever it comes to submitting an online application, all you really are doing is just typing in the stuff. Once you've done that, you will have a separate field. You will see, it will tell you to upload the additional documents, and whatever kind of documents they need, they will say there, so you cannot miss it. So just go along with the application and you will see in the online application where you actually have to upload those documents. So excellent question, Mahruban. Thank you everyone for tuning in. Thank you everyone for asking the questions. If you have any follow-up questions, don't hesitate to ask them in the comments below, and I will, hopefully address it in volume 25. Thank you for tuning in again. Appreciate your time. God bless, and I'll see you in the next video.